Welcome everyone. Before we begin the proceedings, I would like to acknowledge the Ngunnawal people on whose land we meet today. I pay respects to the elders, past and present, and also to all Aboriginal and Torres Strait Islander people here today. My name is Lynette Malloy and I'm the Chair of the International Law Committee of the ACT Law Society. The International Lawyers Committee represents a group of lawyers within the public and private sector who have special interests in international law and who volunteer their time to serve in the committee. The committee is proud to co-host this event in conjunction with the International Institute of Unification of Private Law (INDUA) and the UN Commission of International Trade Law Coordination Committee for Australia (UNCA) is represented by Dr. Dharma Sunita today. I'd like to welcome this afternoon's speakers, William Bridie-Watson, Legal Officer of UNIDROIT, Bruce Whitaker, Senior Consultant of Ashurst Melbourne, and Ashna Taneja, Associate of the Burn Sydney, as well as Julianne Wilkin, General Counsel of the Macquarie Group. Please note that this afternoon's consultation workshop is being recorded. As such, by participating in consultation and asking questions and providing comments, you'll be consenting to your image and your voice being recorded. I look forward to an afternoon of interesting discussion. Without further ado, please join me in welcoming our first speaker, William Bridie-Watson. He will be providing an introduction to the Cape Town Convention on the MAC Protocol. Thank you.
Thank you, Lynette. Just putting everybody IT support to. Thanks so much. So while my presentation comes up, I can thank you all for coming here this afternoon. It's a particularly pleasurable occasion for me to be presenting to you all this afternoon. Having worked for UNIDROIT for 4 years on this particular project, I've sort of delivered these types of consultation workshops in sort of 20 odd countries, but it's very nice to do it in my hometown, being sort of a born and bred Canberran, so it's particularly special for me to be here this afternoon. So can I start with a few thank yous? Firstly to our two partner organisations on this particular project. UNIDROIT is extremely grateful to the ACT Law Society and also to UNCA for partnering with us to organise this event, to invite people, and given that UNIDROIT doesn't have a particularly strong network in Australia, we're particularly indebted to our partners. So thank you to everyone involved, Dharma, Lynette, Suzanne, Barbara, who isn't here, and of course also thank you to my fellow experts who've come in and travelled from Sydney and Melbourne respectively to be here this afternoon. We're greatly appreciative for your time this afternoon as well. It is fantastic. All right. So my role this afternoon is to give some context to today's discussion, in particular in relation to the Cape Town Convention, which is of course the instrument that underpins the MAC Protocol. Now, we have a broad variety of stakeholders in the room today. We have government stakeholders, we have people, we have legal practitioners, we have people from the financing industry, and we have some representatives of the actual mining, agricultural, construction industries here. So I'm assuming there will be quite significantly varying levels of expertise in relation to MAC. So this first presentation I'm hoping will be sufficiently broad to give everyone a sense of how the regime operates, and hopefully provide some context for the subsequent presentation from Bruce, who will provide a little bit more in-depth explanation of how the instrument should operate once it is being finalised. I also thought it would be worthwhile giving a short introduction in relation to Unidroit, the organisation I work for, because again, there's not been a huge amount of Unidroit personnel that have come through Australia in recent years, even though historically Australia's been we're very happy that Australia's been a significant contributor to Unidroit. So Unidroit is the International Institute for the Unification of Private Law. Despite its name, it's not part of the UN. It was established in 1926 as part of the League of Nations. When the League of Nations also fell over at the end of World War II, we became re-established on an independent statute in 1940, on which we continue to exist on the basis of our headquarters agreement with Italy. We have 63 member states. Historically, as you'd expect for something set up in 1926 in Europe, we are historically a very Eurocentric organisation, but in recent years there's been much more of a push to try to move out to Latin America, to Africa, and more recently to Asia Pacific. And as I note there, we recently were granted guest status within APEC for a 3-year period, which has allowed us to interact with a lot more countries within this region at a forum where we can talk to 23 countries at once, which is very useful for a small organisation such as ourselves. As I know, there just under half of the APEC member economies are Unidroit member states, but of course, as an institute that creates treaties that are accessible to all 194 UN member states, we need to also advocate our treaties to non-members, even though they're not strictly part of our institute. As you probably know, our mission is to develop internationally harmonised modern standards for commercial law. And what essentially this means is we're an international legislative body. Our member states pay their contributions in order for us to create international instruments. If we stop doing that, then we cease to have a strong mandate for existence. That being said, I'm very pleased to note we've had a very successful period of international legislating. We've got over 28 international instruments with a particular proliferation in recent years. As has been the international trend in the last 15 years, there has been a move towards soft law instruments, as has been the case with many other international bodies. But thankfully today we're speaking about one of the standout hard law instruments that Unidroit is very proud of, being the Cape Town Convention. Unidroit is one of the three, what they're called the three sisters of private international law, ourselves, the Hague Conference on Private International Law, which is 125 years old, so it's a bit older than us, and UNCITRAL, the United Nations Commission for International Trade Law. And we work very closely with these other organisations in pursuing our similar mandates for harmonising private international and international commercial law. We have, as I said, I'm not going to go through the 28 instruments, but some of those that you may be familiar with include our Unidroit Principles of International Commercial Contracts, which are widely seen as one of the most balanced restatements of international contract law that takes into account both common law and civil law standards, and works in quite a complementary way with the CISG. Of course, we have the Cape Town Convention I'll be speaking about today. The Legal Guide on Contract Farming, which we developed in collaboration with the United Nations Food and Agricultural Organization, also based in Rome. And we also have a little-known aspect of our work that's more and more important, is our work on the protection of cultural property. And we have a convention protecting and regulating the illegal export of cultural objects, which now has over 40 member states, 40 contracting states. Very quickly, as I noted before, Unidroit and Australia have a long relationship together. Australia became a member state in 1973. And even more importantly, not only has Australia been a part of the organisation, but they've actually played a very strong role in leading the organisation. There's been continuous representation by an Australian nominated candidate on the Governing Council, which is 25 of our 63 member states, who elect 25 countries to essentially set the legislative agenda and Australia has been continually represented since 1984, which I'm very proud of as an Australian. And of those people who have sat on our governing council, they have tended to be very esteemed, distinguished Australian lawyers. We've had 4 former secretaries of the Attorney General's Department, including our current member, Mr. Roger Wilkins, whose mandate ends this year, and also people here may also be familiar with Ian Govey, who of course was the head of the Australian Government Solicitor for many years as well, and was a governing council member for 2 terms. Finally, I note that we're also pleased that Australia directly benefited from our work in recent years. So in the last 4 years, Australia has actually implemented in Australian law 3 UDOIR treaties, our Wills Convention, and of course the Cape Town Convention and its partner aircraft protocol, which I'm here to talk about. So moving on to the substance of the presentation, I think it's always best when talking about international commercial law reform to talk about the problem it's intended to address. So the reason the Cape Town was developed was because in the 1980s and the 1990s, it was becoming increasingly difficult to find private sector financing for high-value mobile assets, and in particular in relation to aircraft. In this period, you had a movement towards sort of the deregulation of the aircraft industry, and you had increased privatisation of airlines rather than it being dominated by national airlines. And as a result of that, these privately operated airlines were in need of financing to purchase new aircraft. Now, generally airlines purchase sets. They don't buy just one plane here, one plane there. They tend to buy a fleet of aircraft, a dozen aircraft at a time, which, if you have an average asset value of $100 million, you could be looking at a $1 billion transaction. And it was becoming increasingly difficult for them to find financing for them because of not only because they were high value, but because they were incredibly mobile. So you would say, yes, this is a profitable airline, but in the event of insolvency or a default, if you have these assets sprinkled through 20 different jurisdictions, our ability to repossess those assets to protect ourselves as a creditor is very, very difficult. And as a result, we will either A, not finance you, or B, provide finance at a very, very high cost to mitigate the risk to the credit providers. So as a result of this, a bunch of international secure transaction lawyers got together within UDOIR and said, I think we need an international convention to deal with this international problem. And that was the starting point of the Cape Town Convention. Now, the way they decided to deal with this problem is if you have internationally mobile assets, you need to somehow create an internationally enforceable interest in that asset that can move between jurisdictions. So at the absolute heart of the Cape Town Convention is the creation of an international interest in high-value, uniquely identifiable equipment that is theoretically enforceable in any contracting state, hopefully in any jurisdiction in the world. And that's the absolute basis of the convention. Now, in terms of its application, the convention applies where the debtor is in a contracting state. So where you, for example, in relation to the aircraft protocol, for Qantas to finance, Qantas being based in Australia, for Qantas to finance the acquisition of additional aircraft under the convention, they would need Australia to be a contracting state. It doesn't matter where the creditor is, which is a really important point. The creditor could also be in Australia, the creditor could be in America, the creditor could be in a third state that's not party. That's not the important point. The important point is the debtor is in a contracting state. So the way the convention operates is somewhat innovative in that you have, people refer to it either as an umbrella convention or a wheel and spoke convention. So you have the mother convention itself, the Cape Town Convention, which provides the basic rules, and then you have protocols which tailor the convention to regulate interests in particular different areas of equipment. Currently we have 3 particular protocols that have already been created: the aircraft protocol, the Rail Luxembourg protocol, and the space protocol. And of course we're here today to speak about the 4th future protocol, which will be the MAC protocol. Now, the way these operate is that the Cape Town Convention creates the core rules, but then is overridden in certain regards in relation to each protocol, because obviously the financing of our plane is going to be different in its nature to the financing of a railway rolling stock or a train or a space asset, such as a satellite. So the idea was that you have the Mother Convention, but to tailor the treaty's operation to the particular realities of financing a certain type of asset, each protocol can tailor its application, which is why, in the case of an inconsistency under Article 6, the protocol overrules the Mother Convention. Now, I'll move through these relatively quickly, even though they're somewhat complex, but I've tried to distill the relatively complex operation of this instrument into 6 sort of key features. The first is the functional approach to the creation of an international interest itself. So, obviously what a security agreement or a lease is in different jurisdictions around the world is entirely different. What that means, how you constitute it, how you discharge it. It was realised early on that they weren't going to be able to sort of fit in all these different approaches to those. So instead, what the treaty decided to do was create a functional approach and saying, here are some basic criteria that create an international interest that encompass, broadly speaking, in what different countries consider to be security agreements, sale with retention of title sales, or leases. And this international interest, regardless of whether, if an interest meets the definition and the requirements of an international interest under the Cape Town Convention, it doesn't matter what the domestic law says. So you couldn't go to the court and say, well, under Australia, this is a security agreement under the Cape Town Convention, but it's not a security agreement under Australian law. The convention says no. If it satisfies what we consider to be required for an international interest, it will be applicable and enforceable. So once you have an international interest, you can then register it in an international online registry, which is operational 24 hours a day, 7 days a week. And is searchable and is open and is transparent and is the core way in which you protect the international interest in which you've created. So you've got the international interest, you need to put it in the international registry system. Once you have inserted once you have registered your interest in the electronic international registry, you have a priority. You have established priority of that interest against subsequent interests and non-registered interests. So it became. This treaty made it sort of essential for you to register your interest in this international registry. And that's because once you have registered your international interest, you have priority in the event of an insolvency or of a default, in the event of a default from the debtor. And not only do you have priority by having the first registration in the international registry, you also have access to clearly identified remedies in the convention itself. So the convention says, if you create an international interest, if it's been registered in the international registry, and the debtor defaults or there's an insolvency, here is what you can do as creditor, which is really, really, really important for finance institutions in providing credit to know what they can do if, unfortunately, a deal goes bad. And that is a key part of the convention itself. And finally, one of the more innovative mechanisms that has led to the success of the Cape Town Convention is what's called the declaration system. So in negotiating the Cape Town Convention, contracting states butted heads, unsurprisingly, on particularly contentious issues. The biggest example being insolvency. There is no international consensus on what the best domestic approach to insolvency is. Some countries, historically, for different reasons, are more open to having sort of debtor-friendly restructured insolvency regimes. Other are more creditor-friendly regimes. And there was no possible way to create one rule within the convention that would make all 200-odd countries in the world happy. So instead, the convention said, in relation to certain issues, contracting states have a choice in how they implement a rule. So in relation to insolvency, in the aircraft protocol, there is alternative A, which is broadly seen as a creditor-friendly insolvency rule, and alternative B, which is seen as more of a debtor-friendly rule that reflects the approach to insolvency in continental Europe. And this kind of flexibility allowed the treaty to navigate around some of the more difficult issues that might have prevented it from ever having international effectiveness. Now, the convention has been incredibly successful. Generally speaking, when we speak about, when we try to evaluate the success of an international convention, you look at two issues. You look at uptake, how many countries have actually implemented it, but not only that, are those countries using it? Because there are plenty of examples, I'm sure you all know in the room, of instruments that have a high amount of contracting states, but in reality don't work the way they're supposed to. And in both of those measurements, in terms of contracting states and actual utilisation of the treaty by private parties, the Aircraft Protocol in particular has been an outstanding success. So we have 77 contracting states for the Cape Town Convention, 73 contracting states for the Aircraft Protocol, and in relation to the Aircraft Protocol, you've seen 900,000 plus registrations of interest in aircraft objects, covering over $500 billion in collateral, and the International Registry itself is a non-profit entity, but it's sitting on a fund of $5 million. It's actually been much more successful than they anticipated. The particularly striking feature that I like to point out is, I know there that the Cape Town Convention has 4.25 ratifications per year, which is relatively astonishing because international commercial law doesn't tend to have the same uptake as some of the other areas of international uniform law efforts. And if you look at the two, probably what would be arguably the two most successful international commercial law instruments in the world, the New York Arbitration Convention developed under the auspices of UNCITRAL, and the Apostille Convention, which both have significantly more parties, they've also been around for decades. And Cape Town only was created in 2001, and is being ratified twice as quickly as these other conventions, which would lead you to think that in 2 or 3 decades they will have as many, if not more, ratifications than these other wildly successful instruments. Now, in my last 2 minutes, I will introduce sort of where the idea of the MAC protocol came from before Bruce goes into some of the more in-depth rules. So, after Cape Town took off relatively quickly, it was created in 2001, it entered into force in 2005, it was realised that this model was quite successful. And the 3 existing protocols, the Aircraft Protocol, the Rail Protocol, and the Space Protocol, had already been anticipated in 2001 when they created it. In fact, there's a reference in the Cape Town Convention itself to those 3 protocols. But then the UNIDROIT Governing Council started thinking, this works, what else could we apply it to? And there was a thought that high-value mining, agricultural, and construction equipment could be additional areas where the Cape Town Convention could be beneficial in facilitating international finance and financing opportunities of high-value equipment. And there was a explicit recognition that this would be particularly important for emerging markets and developing countries who tend to be particularly reliant on these primary industries of sort of agricultural and mining. So I'm not going to go into the boring legislative process, but the point is that we're nearly at the end of the creation of the MAC protocol. It's been a sort of a 14-year project under UNIDROIT, although the first period up until 2013 was more sort of consultation and background work, whereas the last 4 years have been the sort of the actual legislative process of having experts creating the treaties. Next year will be the diplomatic conference that will conclude the treaty. At that point, it will be very hard to vary the terms of the treaty, which is why UNIDROIT is working particularly hard this year and over the next 12 to 18 months to ensure that countries understand how it will operate, understand its benefits, its potential costs, and get input as to whether they are happy with the rules and whether the rules will be beneficial to their domestic stakeholders, or whether we need to make more changes to the text. There's been great interest in the treaty. We had 51 countries participate in the governmental expert meetings in Rome last year, which is the the highest at that stage of negotiations in any treaty in UNIDROIT's history, which shows it has a real interest, and we were very pleased that the majority of those states participating were emerging markets and developing states, which wasn't the case for the earlier protocols. And we believe that if internationally successful, it will provide new opportunities for manufacturers, financiers and legal service providers worldwide. And domestically for countries that implement it, it may also create new opportunities for domestic entities to have better access to low-cost credit. And I think this division, which will probably be echoed by my colleagues here, of impacts that will happen internationally, whether Australia ratifies or not, versus impacts in Australia, if ratified, is important to distinguish because given that we have the 51 countries involved in negotiations, we can anticipate this will be a success. The question is, for Australian domestic stakeholders, is it worth extending it to the Australian regime as well to allow the mining, agriculture and construction industries in Australia to take advantage of its provisions. On that note, I'm a little bit over time, so I'll step down. Thank you.
I apologise in advance for my very croaky voice on that. Good afternoon, everyone. What I'm going to talk about the next 15 minutes or so are those 5 topics. First, talk a little bit about Australia's secure transactions legal regime, talk about how the Cape Town Convention operates in Australia, how the two then fit together. Then I'll move on to talk about the main topic today, which is the draft MAC protocol, and also how it could potentially fit in with Australia's existing secure transaction rules. Now, most of this will be pretty familiar with a lot of people in the room, so I'll go through this quite quickly. We currently have a Personal Property Securities Act, which is a quite comprehensive set of rules governing the way secure transactions work in Australia. When it came in, it replaced the pre-existing mishmash of overlapping regimes we had in Australia for secure transactions, and replaced it with one centralised system that applied consistently for all borrowers and for all types of assets. It had at its core one centralised register, fully electronic, accessible 24 hours a day. Now, this is a little bit of background on how secure transactions laws registers work. Typically, they work in one of 2 ways. One set of registers uses at its core the name of the grantor of the security interest as the basis for making registration. So when you register a security interest, you register it against the name of the grantor. Other systems use principally an asset-based system where you don't necessarily register a security against the name of the grantor, but you register it against a description of the asset. And for that type of register to work, you need to have assets that are capable of being described in a sufficiently unique way so that there's no confusion on the register about as to which asset might or might not be subject to a particular security interest. Now, the PBS register uses a little bit of both. It's principally a grantor-based registration system, but also uses an asset-based registration system for certain types of serial number properties, in particular motor vehicles. Now, the Cape Town Convention, as we've heard, came to life in 2001. We didn't become a party to it immediately. We became a party in 2015. That was a couple of years in the making, and the legislation that made that possible was enacted here a couple of years prior to that with the not particularly catchy title of International Entrance of Mobile Equipment Cape Town Convention Act of 2013. The intervening 2-year period was used to sort of fine-tune the process of how it would be applied and to give businesses time to prepare. It became part of Australian law in 2015. Now, from what you've heard me say about the PBSA and from what you've heard Will say about the Cape Town Convention, there's clearly a lot of overlap. They both deal with security interests in property. In the case of the aircraft protocol, they deal with security interests in aircraft objects. But they have quite different rules for how you both create security interests. They have different priority rules for dealing with competitions between security interests, and they have different enforcement systems as well, and as we've also heard, entirely separate registers. Now, because the Cape Town Convention is an international convention, the guiding rule is where there is an overlap between the two systems, the Cape Town Convention will prevail. That's clearly set out in the Cape Town Convention Act itself, also in section 256 of the PPSA. Now, the Cape Town Convention, though, doesn't actually annul the operation of the PPSA in relation to aircraft objects. It simply prevails where there's inconsistency between the two sets of rules. And the practice for Australian financiers is actually just to register under both. And that's because our PPSA is a broader regime and offers some benefits to registration that don't necessarily follow from a registration of the Cape Town Convention, particularly when you're looking at proceeds of collateral. So if you have security over a car, for example, the car gets sold, under the Australian PPSA, your security interest will attach to the sale proceeds. The Cape Town Convention applies a much narrower rule to the notion of what are proceeds, and it will attach an international interest to insurance proceeds, for example, if an aircraft is destroyed, but it doesn't attach to the sale proceeds if an aircraft is sold. So financiers in Australia tend to register under both to get as complete a coverage as possible. Turning then to the draft MAC protocol, before I turn to the draft MAC protocol, the aircraft protocol defines what it applies to, i.e. aircraft objects, through a series of definitions in the aircraft protocol itself. It's dealing with a fairly narrow asset class, and it's got quite specific definitions for the types of objects that it applies to. Relatively easy to apply those definitions to work out whether the aircraft protocol applies or not. Now, that's easy because aircraft are pretty identifiable sort of assets. They're all very high value. It's not too hard to be specific. The boundaries, though, for working out when the MAC protocol might apply, though, are much fuzzier. Mining, agricultural and construction equipment as a concept is a much broader concept with fuzzier edges than the notion of what is or is not an aircraft object. MAC equipment can also sometimes be very high value, such as if you've got one of those large tunnels they use for boring tunnels underneath suburban Melbourne when they're putting in a new railway. They're clearly high value. At the other end, a chainsaw is a piece of agricultural equipment, clearly not of high value. So the drafters had a real challenge to work out how they should try and define what is to be mining, agricultural or construction equipment for the purposes of the protocol. Got to be clearly high value. And the way they've done that is to turn to another international organisation and use its terminology instead. And the organisation they turn to is the World Customs Organisation, which over a period of some decades now has developed what it calls the Harmonised Commodity Description and Coding System, another snappy title, and it essentially attempts to categorise every possible type of goods that is traded internationally. And it breaks it down into a wide number of categories by description. And so what the drafters of the MAC protocol did is they went through all the codes in the harmonised system and worked out which of those codes encapsulate equipment that is particularly relevant to the mining, agricultural and construction sectors and is, for the most part, going to be of high value. And those are the codes. Those codes are then listed in 3 annexures at the back of the draft protocol, and that is what you then use to work out whether the protocol will apply to a particular item of equipment or not. Now, they're listed in 3 separate annexures, one for mining, one for agricultural and one for construction equipment, because the way the protocol is set up, it will allow a state to sign on for 1 or 2 of the 3 categories of equipment, but not necessarily for all 3. So if one particular state doesn't like the idea of it applying, for example, to mining equipment, it can simply sign on for the other 2 categories of equipment instead. Now, Will asked me to put in a little slide with a little bit more information about the harmonised system. I will say I am not an expert on the harmonised system. You're very welcome to ask tricky questions, but if you do, I'll be delivering the will for him to answer. But the important thing to see there is it gets down to almost 5,400 separate categories of equipment. So when you sort of look at the way the codes describe what it is they apply to, they really do drill down to quite a granular level of detail. And so by picking out specific numbers of those codes, 42 of those codes, the drafters have tried to focus the protocol on equipment that falls within the spirit of the convention, which is that it's particularly high value and is particularly relevant to those three sectors. So how would the MAC protocol fit with our PPSA? The same drill really as for the aircraft protocol, which is the MAC protocol would prevail to the extent of any inconsistency between it and the PPSA. That has the potential though to have a much larger impact on the balance of our secure transactions system than the aircraft protocol does. The airline industry has, as far as I'm aware, no local manufacturers, very few industry players. They're all sophisticated and well advised, and there's not a great deal of spillover between the airline industry and the rest of our economy. By contrast, the MAC sectors are really part of the very weave of our economy. They overlap significantly with other parts of our industries as well. There are lots of manufacturers, quite a few based here in Australia, lots of participants. A lot of those participants often aren't particularly sophisticated or well advised. So when we think about how we might implement the MAC protocol as part of Australian law, we need to be aware that it's applying potentially, or it would be applying to a very different segment of the market than the one to which the aircraft protocol has applied. But I'll come back to that in a minute. So what are some of the sorts of things we would need to think about if we were to try and weave the MAC protocol into being part of the Australian legal system? The first thing we need to be aware of is, as I've mentioned, or as Will has mentioned, the register under the Cape Town Convention is an asset-based register, so you have to be able to uniquely identify the asset in order to be able to register against it. Again, easy for aircraft. They've all got those fancy sort of 5 or 6 letter acronyms stenciled on the outside. They will all have manufacturer's serial numbers, relatively small universe of manufacturers, so really pretty easy to be able to uniquely identify an aircraft object when you're doing a registration. Much trickier for MAC equipment though. As I said, there are lots of manufacturers. There is no industry-wide consensus around how you might apply serial numbers to MAC equipment. Some manufacturers might use the same serial numbers as other manufacturers. Some manufacturers even use the same serial number within their own model range, as they might repeat the serial number across different models. So it's a much trickier process working out how we would go about uniquely identifying MAC equipment for the purposes of the registration system. Now, that's still a bit of a work in progress. It will, I think, end up being a combination of a serial number supplied by the manufacturer, and that's actually written into the draft protocol, but the protocol also contemplates that there will need to be additional information provided in order to ensure uniqueness, and those details will be worked out through regulations that will be made by the supervisory authority under the MAC protocol when one has been identified and appointed. So there's still a little bit of work to be done. The second issue we need to think about are the priority rules. Again, Will's touched on the priority rules. He said that under the Cape Town Convention, the rule generally that applies is if you've registered, you win, at least as against later registered interest and anything that's not registered. The PPSA also contains priority rules. They're a rather more sophisticated set of rules than that. There are a range of exceptions that apply for particular policy reasons. For the purposes of the Cape Town Convention and the interests that it was principally targeted at protecting, the priority rules are much simpler, much blunter. Doesn't mean they can't work here in Australia. Clearly they do work in the context of the aircraft protocol, but it does mean we would need to just think through some of the ramifications of having such a short and sharp set of priority rules compared to the ones we have at the moment. The third area to think about what secure transactions lawyers call the taking-free rules, which are the circumstances in which a buyer of an asset can acquire the asset free of a security interest the seller might have previously granted over the asset. Now, aircraft are obviously very complex instruments, complex machines, but the industry that they operate in isn't particularly complex in terms of the sales processes. As a rule, one of the big aircraft manufacturers makes an aircraft, and they typically just sell it straight to the end user. There aren't a lot of intermediaries that get in the middle of that sale process. Again, very different from the Mac sector. In the Mac sector, it's quite uncommon for the manufacturer to sell directly to a farmer or the miner or the builder who ends up using the asset. The manufacturers typically sell to distributors, and the distributors then sell to retailers, and it's then the retailers who on-sell the equipment to the end user. Now, most sophisticated legal systems recognise that if you go into a shop and buy something, when you walk out the door with the asset and you paid your money, you expect to get good title to it. You don't care if the shop owner might have given a mortgage over its equipment to its bank to finance the inventory that's sitting on the showroom floor. You expect when you pay your money to get clear title. And most legal systems will allow for that. The PPSA, for example, has a rule that says that if you buy equipment from someone who sells it to you in the ordinary course of business, then you get clear title. The aircraft protocol doesn't have a rule along those lines in relation to aircraft, again because aircraft don't typically get sold as inventory, so it wasn't a big issue. But again, because Mac equipment does regularly get sold that way, it is an important question for the Mac protocol. And so for that reason, the Mac protocol contains a take-and-free rule that isn't in any of the existing 3 protocols, and it is targeted expressly at that question, which is that it will allow a buyer of inventory from a dealer to take free of registered interests under the Mac protocol, despite that general rule in the Cape Town Convention, which is that if you're registered, you're protected. So that certainly goes quite a way towards dealing with what I think would have been one of the main concerns for Australian industry under the Mac protocol. Another issue relates to how, I've mentioned that shop owners or distributors often borrow money from the bank to finance the inventory that they have sitting on the showroom floor. If you're a distributor of farm machinery, for example, you'll be buying tractors and crushers and slashers all the time and selling them. If you're a financier to that particular business, it would be a real pain in the neck for you if every time they acquired a new asset from the showroom floor, you had to go off and do a fresh registration, because that was the only way that you could protect your security over that asset, and you then had to go and release the asset when the owner of the business then on-sold the asset to the end user. Again, not an issue for the existing 3 protocols, because inventory finance isn't a big part of the industries that they operate in, but very important again for the MAC protocol. And the MAC protocol again does attempt to address this issue, not in this case by trying to build in a bespoke solution into the language of the protocol itself. Instead, what it does is it actually allows states to do a selective opt-out, if you like, from the convention. So what it says is that a state, when it signs onto the convention, it can elect to say that if you have a dealer who gives security over their inventory, then that security will not be an international interest for the purposes of the Cape Town Convention, which means the convention's rules will not apply, and the state can apply its own bespoke inventory financing rules instead. So again, if the MAC protocol were to be enacted as part of Australian law, that would be good news for inventory finances, because it means you would not need to do a registration against each tractor when it goes on the showroom floor. You could use the PPSA's rules instead. And as I said at the outset, the PPSA rules are principally based around the concept of registering against the grantor. So the financier would just do one upfront registration against the owner of the showroom, and that would then affect all the security interests over all the assets as they came in, and would allow the security interest to be released from the assets as they were unsold. So again, that would be good news for the way the Australian markets work. As you probably gleaned from what I said though, if the MAC protocol were to become Australian law, it would certainly be adding back in some of that complexity that the PPSA tried so hard to get rid of, because even with the ability to provide for inventory finance, and even with that bespoke taking free rule for buyers of inventory, people will still need to be able to work out whether or not the MAC protocol does actually apply to an item of equipment. and you will have two sets of rules running alongside each other, one depending on whether the protocol does apply, and one depending on whether the protocol does not. That's not necessarily fatal by any means, but it does elevate to some extent that threshold question of what are the benefits that Australia would gain from signing on to the protocol, and do we believe that those benefits would outweigh some of the unavoidable disadvantages that might flow from doing so. Now, to finish on hopefully another slightly positive note, there is a partial solution to all of this at least, which is that it may be possible to use the PPS register as an entry point into the Cape Town Convention's international register as well. So this would require a bit of a redesigning of the PPS register, but once the rules that help you work out whether or not the MAC protocol is going to apply have become sufficiently clear, it may well be possible when you go onto the PPS register to do a registration that you could be asked some additional questions that would help you to determine whether you then also or instead might want to be doing a registration on the international register under the MAC protocol. Now, that would require a fair bit of work, and we wouldn't be able to tell exactly what the work involved until the MAC protocol itself has stopped moving around. But I think, well, that would be at least a partial solution to some of the changes. I suspect I've well and truly over time, so at that point I'll stop. Thank you.
So now we have a question and answer session. I don't know how you want to do this, but maybe if we go out to so if you've got any questions, maybe raise your hand, provide your name, what organisation you're from, if you're in a professional capacity, and ask your question to the panel. So any questions?
Whitaker, you mentioned about using the PPS register as the entry point to register later and the back register once it comes in place. So when registration is in both registers, as you said before, will the MAC register override the registration in PPS register in case of inconsistency? And I'm unable to envisage what sort of inconsistency will arise, but will that be the case?
Obviously, that all depends on how it's designed, but it shouldn't. In the same way as with the aircraft protocol, at the moment you can do a registration on the international register convention, and you can separately do a registration on the PPS register. I would envisage that even if it was set up so that your entry point into the international register where it was through our register, it would still be possible for the system to allow you to end up with a registration on both. And indeed, I think that would be important because, as I said, there are respects in which the PPS system is broader in the way it works than the Cape Town Convention, and it would be important to be able to have the registration on both.
Will there be a possibility of inconsistencies arising between the registers to apply the rules of that register providing?
It shouldn't be. It would require a fair bit of work to work out how to make the PPS register work effectively as an entry point, because the questions you get asked are a bit different.
Okay.
And so it would expand the number of questions that you would need to answer in order to do your registration, but I think that's design. It's not impossible to do. It's just a question of getting the design right.
Any other questions?
Jason Soblov, I'm a member of the International Lawyers Committee of the ACT Law Society. One paper I read on the way here in talking about the aviation protocol was critical of the lack of description around how export credit agencies would operate in relation to the Cape Town Convention as a whole and the aviation protocol more specifically. So in that particular case, an export credit agency being a quasi-governmental lender that has the backing of a government, and in this sense somewhat taking it outside the private international law space and giving government a particular interest in infrastructure, but being one step removed from the actual lender. Do you have any position on ways that clarity could be given around the role of ECAs in the MAC protocol and the Cape Town Convention?
That's a really good question, and especially given that similar to the aircraft industry, the ECAs are very active in providing large amounts of finance for the export and for the financing of MAC equipment. I'm not sure of the exact paper you're referring to, but I would imagine that the potential lack of clarity is around the interaction between the regulation imposed by the OECD on export credit agencies and how they're treated as a financier under the aircraft protocol. In 2012, the OECD passed something called the Aircraft Sector Understanding, the ASU 2012, which essentially said that contracting states that implemented the Cape Town Convention and the Aircraft Protocol, where they made certain declarations that were particularly favourable to creditors, then export credit agencies were allowed to offer a certain deduction in the cost of provision of finance. And this was a large motivating factor in a lot of countries in implementing the protocol. That aircraft sector understanding does not apply to every country, and I think there is often some confusion among contracting states as to whether they can access this particular reduction in financing from export credit agencies under the OECD agreement, which is separate from the Cape Town Convention, and secondly, even if they're theoretically eligible, what exactly rules they have to implement under the convention to make sure they actually get it. And both of those questions are somewhat complex. So if that's the issue around sort of how export credit agencies are inconsistently treated under the aircraft protocol, that may well happen again under the MAC protocol. What it would depend on is whether some sort of sector understanding was also passed by the OECD in relation to MAC equipment, insofar as if the OECD said, well, in relation to aircraft, we're convinced that this does enhance creditor rights and enhance transparency and predictability in the provision of finance across borders. Hence, we allow ECAs to offer discounted finance in aircraft. If they looked at MAC and said, this is the same case, we can do it, then you would have the additional benefit for contracting states, but you might also have the additional complexity. That being said, we haven't engaged with the OECD at all at this stage. We need to finish the treaty and look at sort of the countries that are implementing it, I think, before. The OECD aircraft sector understanding wasn't put in place until well after the Cape Town Convention and the Aircraft Protocol entered into force. So I don't think that would be a question we'd have any clarity on probably for a few years.
Just an observation though, that Boeing, for instance, subsidiaries were acting as lenders prior to the Cape Town Convention though. So it's interesting that slipped through the gaps and is still under debate.
In what sense?
The operation of ECAs in the aviation sector, and their practices were preferencing some purchasers, some debtors over others, and those corporate practices predate the Cape Town Convention. Just an observation that
absolutely
it's made it from A to Z without being resolved yet.
Certainly, and I doubt that the Cape Town Convention would resolve that, but it's certainly a point that does impact on its actual sort of impact on the ground in countries that implement it, certainly in relation to their access to ECA credits.
Hello, I'm Suzanne Howard, and I'm also a member of the International Lawyers Committee with Lynette and Jason. A question for all members of the panel. Are there any elements is there any work of the Hague Conference that we should be looking at this time in conjunction with the MAC protocol and the PPSA work? Because clearly there's quite a bit of overlap in some of these areas. I shouldn't have any observations.
I could speak quickly to the Hague Conference work. Of the usual sort of traditional overlap that perhaps Bruce and Ashley can speak to is the UNCITRAL UNIDROIT overlap because of their working group, secure transactions that Bruce is heavily involved in. But in relation to the Hague Conference, off the top of my head, I would say that the Choice of Court Convention is one where you have overlap but consistency in relation to the two instruments in that. I think it was the 2005 Choice of Court Convention that has been implemented, is now enforced because it's been implemented across Europe. Essentially empowers where two parties have elected in an international contract a particular jurisdiction to have sole jurisdiction over a dispute under that contract. If that court is an contracting state and they're required to hear it, or if it's in a non-contracting, or if it's a third state, they're required to offer a stay to have a stay in relation to that the actual jurisdiction as chosen by the two parties. Now, in the Cape Town Convention, there is a similar sort of default to the will of the parties in determining sort of choice of law and choice of court. So in that sense, they are compatible. And you know, as one of our sister organisations, we would encourage all states to also implement the choice of court convention. Because the Hague Conference tends to work more on traditional private international law, you know, how you actually go about a dispute between private parties in different states. There's not too much substantive overlap in terms of their work with the Cape Town Convention, I don't think.
Well, I don't have specific knowledge about the UNCITRAL instruments. There are a number of instruments on secure transactions, and there's definitely overlap. But given that Bruce is the chair of that committee, I think he's probably better placed to give you the nuances of the overlaps.
I hope you might learn something. Look, yes, the main work piece for Working Group 6 of UNCITRAL over the past few years has been its model law on secure transactions that it released in 2016, I think it was. It is a model law that tries to do the same job essentially as our PPSA. It's worded quite differently, it's organised a bit differently, but it's based on the same underlying principles. So I think the question that was implicit, the point that was implicit in the question you were asking is quite right, which is that if a state implements both the UNCITRAL model law and the MAC protocol, then they will need to think through largely the same sorts of issues as we've been discussing here today to make sure that the two work hand in glove. Sorry?
Same on the insolvency component that you raised.
Yes.
Might just take one final question, give me a short behind time.
Nadine Bajaj, I'm from Treasury. I had a question that is perhaps a little bit tangential to the whole thing, but in light of the recent Royal Commission into banking practices, and given that we know that the agricultural sector is particularly vulnerable to overfinancing and high-risk financing, or financiers perhaps taking advantage of agricultural sectors, which wouldn't be a problem obviously in construction and mining comparatively. Is there anything in the MAC protocol, has there been any consideration given to the protection toward the people who are more vulnerable in these areas, who would be taking out security financing on agricultural equipment?
I don't think there's a specific provision that addresses that. I think it is left up to the domestic legislation to address that. Is that right?
Yeah, that's entirely right. I guess to a large extent, the MAC protocol is based on party autonomy. It gives a lot of the express remedies, the particular remedies that creditors enjoy are only available to the extent that both the debtor and the creditor have agreed to them under the security agreement. So it's sort of, occasionally we go to countries and we get the feedback, oh, this sounds like a way to allow, the big banks to come in and enforce their interests, international banks to come in and enforce their interests in an unfair way. And our response tends to be no, because these particularly strong remedies that creditors have under the protocol are only available if the debtors agree to them in their security interest. And for us, it's kind of a trade-off. If a debtor wants access to lower cost credit, then they have to be willing to grant the creditor additional powers to repossess the equipment in the event of an insolvency or a default. So that's the way we sort of say to states, this gives you an additional option. It's not a super blunt instrument in that sense.
And the other thing worth bearing in mind is the convention it's not a fully self-contained and complete set of rules by any means. It contains a set of fairly bare bones mechanisms to deal with certain aspects of taking and enforcing security rights. The convention quite clearly recognises that the entire body of a domestic legal system's rules can sit behind the convention, so anything around unconscionable conduct, fraudulent conduct, all those parts of a state's legal system will continue to apply regardless of the fact that the convention might be adopted.
Can I just ask one quick, hopefully be a good question, because we have sort of an answer on the aircraft side already, but ours, we know how this is going to interact with the new ipso facto stay regime that came in reforms, because I know that the aircraft interests are excluded, so would we apply the same, has that been discussed, or?
It's a very good question, and Will and I were just having a chat about this earlier
Discussed half an hour
and I said I need to go away and think about it. So I don't actually have an answer for you, but there is clearly the potential for the two to interact. I think the ipso facto rules do so they don't apply where the convention does, but there's a lot around the way the convention works that might not prevent the ipso facto rules being able to apply, because the ipso facto rules, by and large, limit the circumstances in which a financier can call a default if the default is based on an insolvency of the debtor.
Yep.
The Cape Town Convention doesn't try to define what is a default. It simply says if there is a default, then the financier can do certain things, and it leaves it to the applicant law to decide what can or cannot be a default. So it may well be that the ipso facto regime will operate almost despite the carve-out for the Cape Town Convention, because what the ipso facto rules speak to is a slightly different stage in the process than the stage, the security stage, which is what the convention deals with. But that's very much shooting from the hip response. It is something I need to go away and think about a bit.
We might just move on to the panel session on the global economic impact of the MAC protocol and benefits for Australia. And we know we're about 20 minutes late. What else behind agenda, which we knew was going to happen.
I promise I'll be much more brief this time, so we have plenty of time for further questions at the end. The way we conceived of today's consultation was to talk about the legal rules first, and then talk about the potential economic benefits that might flow from the implementation of the MAC protocol, both on an international basis, assuming that it does have the international success we hope it will, and separately what the benefits and costs would be, in particular for Australia, should they consider ratification. I think Bruce did a wonderful job of explaining some of the legal issues that might come up, and we hope to sort of bring some broader context to the costs and benefits surrounding those actual legal changes. More and more from our member states, we see the core question when new projects are proposed is how much will this help us or how much will this cost? And I recall from my time at Attorney General's that at any given time there might be a dozen or so treaties that would be in Australia's interest to implement, but in terms of JSCOT's opportunity to hear them, or to the extent that there's only limited bureaucratic resources to implement them, you need to have a hierarchy. And the aircraft protocol managed to jump up that hierarchy quite quickly because Qantas was able to say, this will be of great benefit to us, we need this ratified in Australia. And on that basis, a sort of ex-ante estimate of the economic benefit of the MAC protocol has been, and of the previous protocols to the Cape Town Convention, has been a very important aspect of our work and of our promotion of the instruments. I won't go through this in detail, but as noted here, we can make these slides available. The aircraft protocol has its own economic impact analysis that's noted that it saves about $2.6 million in the acquisition costs of the new Airbus A380, and that was specifically referenced in the JSCOT hearing for the aircraft protocol in Australia as one of the motivating factors. We've recently had a similar sort of regional impact analysis done for the Luxembourg Rail Protocol for Europe, which had similarly positive results of sort of a potential impact of $20 million for a group of 20 countries within Europe. And on this basis, during negotiations last year, there was a request from the 51 states party to the MAC protocol negotiations. They said, we want to know what this will cost and how much it might benefit us. So on that basis, UNIDROIT went out and engaged a independent team of UK economists to prepare an economic benefits or economic assessment paper. A preliminary report was delivered in Rome last year, and we're finally now getting around to the release of the final report, which should be in fact available next week. So this is the first time, although we already have the figures, so this is the first time we'll actually be able to mention them in a national consultation. Essentially, the key findings of the economic assessment was that there was a high degree of uncertainty whenever you do an international assessment of the economic impact of a treaty that could impact, 50 states, could impact 190 states, but that it's very, very likely that the benefits of the MAC protocol will significantly outweigh the costs. It notes that the MAC protocol will apply to about $100 billion of equipment traded across borders per year based on UN data, and those 42 harmonised system codes that Bruce mentioned earlier that define the scope of the protocol, which we anticipate will cover the kind of high value harvesters and not the $100 lawnmowers. And it should improve access to finance and reduce credit risk in countries that implement the protocol. Essentially, it indicated that it took a 10-year period for the analysis and said that it should increase the stock of MAC equipment in developing countries by $90 billion per year over a 10-year period, and that it would be predicted to have a positive economic impact of $23 billion in developing countries and $7 billion in developed countries, for a total GDP equivalent impact of $30 billion a year. Now, they also did a sensitivity analysis around that number, and they said, we believe it could be 30, but it could actually be anywhere between 8 and 90. There is a high degree of uncertainty, but their sort of key finding was, even on the most pessimistic assessment, even if it was only 8 billion per year, that would still far outweigh the very minor costs of the implementation and creation of the instrument, which is that final point there. Now, as I've already mentioned very quickly, that it should be finished next year in terms of the negotiation of the treaty. Of course, creation, adoption is very different to entry into force. The convention currently provides that you need 5 contracting states and a functional international registry before entry into force. And we would hope that that could move relatively quickly, as it did with the aircraft protocol. So you could have entry into force within a few years after the creation of it. My final thought, I guess, is often when we're speaking publicly about the MAC protocol, we're asked why we think it will be a success, and sort of doing a historical analysis of the 28 legal instruments UNIWA has produced. There seems to be 4 criteria that always come up that define whether they're a success with 77 states or a failure with 1 state. I'm not going to say which is which, but it seems to be those acceptable legal rules, a predicted economic impact, support from the private industry, and support from states that may implement it seem to be the 4 magic criteria that lead to a successful instrument. And given that for the MAC protocol, the legal rules are based upon those that are already working in relation to the Aircraft and Cape Town Convention, we now have an independent analysis saying there should be a demonstrable significant economic impact. We have a very, very positive view of the MAC protocol from what's called the MAC Working Group, which is the private sector non-profit body that participates in negotiations on behalf of the private sector, that represents financiers, end users and manufacturers of the equipment. And finally, as noted, we have 52 states already involved in negotiations, and we would anticipate many more than that will actually turn up to the diplomatic conference next year. So on the basis of that criteria, we're very hopeful that the MAC protocol will be a successful instrument. Thank you.
So I won't take up too much of your time, but I'd like to speak very briefly about the potential economic impacts that the MAC protocol could have on Australia. In order to do that, I think it is important to first have a look at how the MAC industry is in Australia, how big it is, the value and the direction of trading in MAC industries. Then, just briefly, the potential benefits, looking both at those benefits that would accrue if Australia ratified, and those benefits that would accrue if Australia encouraged other states to adopt it. And then finally, touching upon some of the implementation costs that needs to be balanced off against. So, MAC industries in Australia are actually quite strong, and they account for a significant proportion of Australia's economic output. So if you look at some of the 2016 to 17 figures for Australia's gross value added, you can see that mining took up 6.3%, agriculture, forestry and fishing 3%, construction 7.9%, which in total is about 16.9% of Australia's gross value added, which is relatively significant. On top of that, Australia's agricultural exports are ranked in the top 12 by value in the world. And in US dollars terms, it's about $33.8 billion in 2016. So these are quite significant figures, quite a large amount of activity going on in this particular sector. On top of that, it is important to note that the MAC industries are employing a significant proportion of our workforce here in Australia. So you can see there that mining's taking up 1.8%, agriculture 2.6%, and then construction 9.4%. So needless to say, MAC industries do make a significant contribution to Australia's economic output. One of the key things that is important to a successful MAC industry is capital inputs, which is where MAC equipment comes into the picture. Unsurprisingly, given the size of the MAC industries in Australia, Australia is a net importer of MAC equipment. And in fact, a while ago, when I was doing a little stint at UNIDWA in Rome earlier this year, I did actually go through those commodity codes that are annexed to the MAC protocol, and they're available on the UN Comtrade data website. And I went through them and sought to identify the direction of Australia's trading in MAC equipment. And I've got actually a table which I might be able to. So my analysis took me to this table which summarises my findings, which was that overwhelmingly Australia is a net importer of MAC equipment. So this is the aggregate amount of all those 42 codes. You can see pretty much almost consistently since about 2013, 2014, Australia's been importing about $2 billion worth of MAC equipment. So what that tells us is that the MAC protocol has the potential to impact on about $2 billion worth of goods coming into the country. There also is a little bit of export activity going on, but you can see that those numbers are around the 500 million, just million. So still significant, but nowhere near as large as the importing activity. And I think that's important when you come to think about the ratification implications in particular. So going back to going into the potential benefits. So the three key benefits that are generally identified from the MAC protocol are, they first stem from the effective enforcement of securities. So the fact that financiers can enforce their security in the event of default or insolvency effectively without having to look at and have recourse to domestic rules, that uniformity makes it easier and cheaper in terms of regulatory compliance, particularly for multinational financiers. That then leads to greater access to finance over MAC equipment and cheaper finance over MAC equipment for purchases. More specifically though, if we look to, and this is probably what you'll all be most interested in, if we look to the benefits and if we look specifically at those that accrue if Australia ratifies and those that accrue if Australia encourages other jurisdictions to ratify. Firstly, looking at those if Australia ratifies. I think there are three key benefits that are worth considering. The first is that relating to lower cost of credit through easier enforcement capabilities for financiers. And that's built into that specific transaction. So when a financier doesn't have to go and learn Australian domestic law in order to be able to enforce its security, it can then extend to Australian importers better cost, better financing terms as well. The second thing that I think is worth mentioning is that for financiers, the status quo probably provides a system by where the markets, where their target customers lie, is perhaps more separated across the globe. Mainly being because after a certain point, the risks of enforcement due to the mobility of the assets just is too great. But with the introduction of the MAC, and given the uniformity of the rules, it's likely that there are going to be international financiers that may be interested to then extend finance to Australian MAC importers. That would increase competition in the finance industry, which would again lower the costs of finance for importers. Finally, I think it's also worth mentioning that as the MAC protocol gains traction, and it seems from what Will has already mentioned that it is gaining a lot of popularity and has been gaining traction generally across the world, there will be a signalling effect to businesses in adopting the convention. Businesses are going to see adopting the convention as a signal of ease of doing business. So I think those are three key benefits from ratification that are really worth thinking about for Australia. But even if Australia doesn't ratify, there are also 2 other benefits that would accrue to Australia. The first, of course, is for MAC exporters and MAC financiers. So those individuals are going to be most impacted by whether or not other countries adopt the MAC protocol. So it's in their interests to have those jurisdictions adopt the MAC protocol to see all of those benefits enforcement-wise. But second, over time, as the MAC protocol is adopted, the general cost base for financiers is going to improve. The regulatory compliance costs are going to decline. And those spillover effects of altering the cost structure of international finance is likely to spill over to Australian importers of MAC equipment as well. So, of course, this has to be balanced up against the costs of implementation. Bruce has already taken you through how the MAC International Registry could potentially interact with the PPS register. And that's something that we're going to have to think about if we do consider implementing and adopting the MAC. Furthermore, whether or not the search costs associated with having an international register in addition to the PPS register is another consideration that will be needed to take into account when considering whether or not to adopt. So I think where that leaves us is that it is in Australia's economic interests, at the very least, to promote the MAC protocol, particularly to its trading partners. Because if it does, it will reap the benefits, particularly those who are MAC exporters of MAC equipment or are financing MAC equipment overseas. Furthermore, Australia could also directly benefit from ratification through access to better financing terms and reduce the costs of financing. That's all from me.
I'm happy to move that.
Well, should we open up to the floor again for the last half an hour?
Yeah, I've just got a broad question, noting that many in the room will be legal practitioners, and it's not specifically on that, but it's on the Cape Town Convention. When it comes to registering an interest on the register, are there any special requirements, tips? I'm having a stab in the dark, and many of us probably haven't actually registered anything on the register. Are there any tips that you guys can give? Are there any specific requirements required by the register operators?
I think that the best guidance we can give you is that there is because of the great risks associated with misregistering an interest for a $300 million plane, there is a huge amount of guidance out there for practitioners in relation to correct and efficient use of the International Registry. Both from the International Registry itself, they have a very innovative sort of video guide as to taking you through each part of the registration process that's very, very sort of user-friendly, especially in sort of legal sectors that aren't always operating in such a modern fashion. And there's also something called the Aviation Working Group, which is similar to the MAC Working Group, is the private sector representative body that provides input into the Cape Town Convention and the aircraft registry. And they have a legal advisory panel that's full of lawyers in the aviation industry who have to, on a daily basis, make and discharge registrations on the International Registry. And they have a comprehensive brick of a practitioner's guide to assist practitioners with the use of the International Registry to ensure there are as few errors as possible in making registration. So the Secretariat doesn't deal with that in particular, but we're pleased that there seems to be
sufficient information out there to assist practitioners.
And to follow on then, is there a fee associated with registration?
Yes. So there's fees associated with registration and there's a search fee. The fee in relation to registration is about $100 a search, and then you've got a sort of simple search and a priority search, and the $100 registration fee in relation to an aircraft engine or aircraft asset is
Minimal. Okay.
Yeah, very, very minimal. We often get asked what the registration fee under MAC would be. It will depend on a variety of factors. The registry just needs to the registry is not allowed to be a profit-making body. It has to only recoup enough fees to cover its operation. But sort of one of the stranger things that's happened with the aircraft registry, as I noted in my presentation, is they've actually generated $5 million that they didn't intend to generate, and actually they don't actually they've invested as much as they can in the infrastructure, and they've got this fund still. So it would be hoped that given the lower value of potential assets in the MAC industries, it would hope that there would be a lower registry fee associated with it, but of course that will all be worked out at a much later stage in the process.
Thank you.
I'd add two thoughts. That one was the slightly flippant one, which is registering on the international registry certainly could be any more difficult than registering on the PBSR. So there's got to be an improvement in there. Either way, I would say, apologies, anyone in the room might be offended by the observation. The other thing I would say, excuse me, in between croaks, is that certainly a $100 fee for registering an international interest in a piece of MAC equipment is proportionately a larger slug than $100 for registering against the aircraft. But as Will said, the register is run on a cost recovery basis, not to make a profit, and there's an awful lot more MAC equipment out there than there are aircraft, so you would assume that there'd be more and more registrations, and because it's fully electronic, having twice as many registrations doesn't double the cost, so you would hope over time that as the MAC protocol becomes more successful, more stuff gets registered on the registry, that the cost per registration will come down.
Economy of scale.
Yes, that's it in a nutshell.
Hi, I'm Julianne. I'm from Macquarie Group, and I'm General Counsel for our Asset Finance Group. So we finance MAC equipment globally, and we've had a particular interest in this, more from a global perspective, but more recently from an Australian perspective. And so I must say I agree entirely with Ashna's presentation. I've never met Ashna before, and I hadn't seen that presentation before. But I just a comment from our perspective as a global financier with an Australian head office, we see this as being hugely beneficial to MAC participants globally. But also, I think the more we've looked into this, in Australia it will be hugely beneficial as well. A lot of what we do is we provide the finance locally, but it needs funding from somewhere. And so even for us, we're talking to the banks in Japan and Korea and in the US, and if they can get their heads around very easily what these assets are and how they're secured in Australia, it makes our process of raising funds a lot easier, even on a wholesale perspective. So we see Australian benefits coming from this. As well as obviously, in Brazil, for example, we finance assets there. We could spend $50,000 on legal fees to understand the local regime in Brazil. I'd be happy to spend $200 for a registration on the protocol if that was an alternative. It really would be hugely beneficial for us. And I think also domestically here, if you've got more international financiers who, the PPSR, I mean, from my perspective, having been an Australian lawyer for some time, we've got our heads around it, but it's unique, similar to the New Zealand regime, similar to the Canadian regime, but different, and therefore international financiers can tend to stay clear or spend a lot of money in getting up to speed on it. So something like this really would, I think, be beneficial here.
Any other
questions or comments? Panel? Any other further comments?
I guess from an institutional perspective, we encourage countries to engage with the process at this point. Obviously, for governments, we encourage them to come along to the conclusion of the treaty, and with a mindset are the rules reflective of how we think Australia can best benefit from that, and will they create a internationally robust regime? Where I can say I was very pleased that we've had Bruce as the Australian designated expert at the two Committee of Governmental Expert meetings last year in Rome. We hope to be able to announce in the next month the location and date of the diplomatic conference next year. It's likely to be in an emerging market in order to ensure that we have a high degree of participation from emerging market countries where we believe, based on the economic assessment, it will have the biggest impact. And I'd also mention that for the private sector, there is this MAC working group that indeed Macquarie is a leading partner of. This is both for the financiers, for the legal practitioners, and for the manufacturers of the equipment. We strongly urge you to join the MAC working group. There's no cost associated with joining it, to ensure that your interests are represented at the negotiations as well, because there's no point in us negotiating a treaty that all the governments agree to, but the private sector finds useless. So that the MAC work group is one of our key partners in making sure we deliver a balanced and useful treaty.
Bruce, Ashna, any comments?
No.
Somehow we stood up in time. That's okay, only by 20 minutes. So I might just welcome Dr. Dharma Ganita. He's the UNCAR Deputy Chair and Assistant Professor of Law at the University of Canberra.
Being the one to stand between the audience and drinks is always a very big role to take. So I'll keep it short. I would like to thank for a very informative night and presentation. Now, my background is not in security interests. And when I first came over the topic and the name and the plan for tonight, I looked at the MAC protocol and I had a mental eye roll thinking yet another acronym that is outside my comfort zone and I don't know what it means. And then I started doing a little bit of research. Mining, agriculture, construction. And my first reaction was, that is this country's Big Mac. Because these are the leading industries for Australia. And given Ashna's very detailed presentation on the economic side, I will not repeat some of the numbers, but mining, agriculture and construction apparently form such a huge proportion of the GDP, of the employment source, of import and export, that they have a huge economic impact on so many levels. And my background is in legal harmonization in general. So for me, these two were like, that's a win-win match. Because legal harmonization is a nice thing in principle, but unless you have an economic benefit attached to it, it becomes an idealistic endeavor. And I think with this piece, and with the Cape Town Convention more broadly, we have that combination that makes legal harmonization really an efficiently moving forward process that actually makes sense beyond the technical legal aspects. And we'll talk about the success of the convention, and that's exactly the reason for that success. And I think we can expect the MAC protocol to follow that success simply because of the size of the industry and its economic relevance within Australia. So without pretending to know more than I do, which is minimum, about the MAC protocol in general, what I just want to reinforce is that states have a great deal to thank to the UNIDROIT, the UNCITRAL, and thank you for raising it, Suzanne, the Hague Conference. And of course there is overlap between the work and the effort of these organizations, but it's something that I don't think many states actually realize how much it matters that those organizations put in the heavy lifting in developing those texts that will then enable the member states to just get the best of it and have the legal risk-free, transparent, legal harmonized system and the economic benefit that comes with it, right? So I think, just thank you. We invite the government representatives, if any, to take these ideas on board. There will be another consultation process with probably heavier industry representation in Melbourne next week. And we will produce some written report out of these two events that can then further inform the broader audience that is not here today. And we will also provide a recording from tonight for anyone who wants to just follow up on details or wants to sort of spread the word. And I would just invite you to put our hands together for our wonderful panel. And have a drink and share further thoughts and concerns sort of off record outside.
Thank you very much.